application for bail
Lordship may be permitted to mention Lordship inclusion in the list. This is CRMA 856 and 850.
Give it. No upgradation, sorry. Give for inclusion, give it. Yes. Inclusion, just hand over. No upgradation, sorry. Very good. Sorry, we are not allowing upgradation, Mr. Shah. Yes, call the list next.
Lordship, for clarification of bail amount. Yesterday's
Clarification.
so Lordship, the bail amount mentioned is 25,000 with two sureties of life amount each. So there is a issue whether it is 25,000 for both or 12,000.
To be mentioned tomorrow. Yes, madam. Call code.
Item number 1.
Lordship, correction is petitioner advocate name, Lordship. It's should be Kumar Shantanu.
Kumar Shanu.
Kumar Shantanu.
Oh, Kumar Shanu. ঠিক আছে অর্ডার দিতে হবে না ইট উইল বি ডান এই ঠিক আছে দেব
Item 2 the correction.
ও সেই সিন এটা হচ্ছে ডেটটা কারেকশন
এই অর্ডার লাগবে না এমনি হয়ে যাবে কারেকশন
না অর্ডারটা কালকে আমরা
ও সেম অর্ডার
সেম অর্ডার ঠিক আছে জানে ও দেবজ্যোতি জানে ওই করেছে
My lord, item number 3, praying for a short passover.
4. 5.
5 also take.
6.
শর্ট পাস ওভার
State is a short passover. CD has just arrived now. Fast.
7. 8.
7.
Seven.
The petitioner. 7. Well, short passover.
8. 9. 10.
Mr. Virtual Mr. Rokon Bonik is appearing. Item 9.
স্টেটের কেউ দাঁড়াচ্ছে না
দেখো
For the customs.
হি ইজ নট দেয়ার পাস ওভার
Lordship 10 and 11 also short passover.
12. 13. 13.
মানডে
পারলে না কালকে
মানডে বলছি
ঠিক আছে
14.
Make it not to them.
টুমরো নট টুডে
So 49 for the picture.
এত সময় নেই আগে তো 4টে দিন 3টে দিন অপেক্ষা
13 not.
এত সময় লাগবে
Item 14.
Madam for the picture.
14 year there
Yes.
yes what was seized
Seized 272 strips of cash sold. Petitioner is custody about 407 days, my lord. Charge sheet submitted, my lord, on 19 March 2024, my lord. And my renewing my prayer for bail, my lord. My prayer for bail was twice rejected, my lord. Page 8 and 9, my lord. Till today, charge not claimed, my lord. Only date fixed for supply of copy, my lord, production. 407 days, my lord.
yes
Yes, my lord. Today has been fixed for charge hearing for charge hearing, but CD is called for. Yes, I have already. And
today is fixed
today is fixed for hearing of charge.
Production, not charge. Only supply of copy.
CD is here
Today is fixed for charge for lower code, your lord, trial code. But they prefer this application for consideration of bail. That's
No, my
why
lord.
CD is called for.
This is wrong, my lord. Date fixed for supply of copy, my lord. Kindly see the last order, and I am the web copy, my lord.
anyway how many witnesses to be examined
Total 18 witness.
18
18, 1-8, my lord. I am a custodian of 407 days. my lord.
So earlier occasions, they have preferred this bail applications, your lordships, and second time, same grounds they have. Actually, when matter is fixed for trial court,
Yes, so 400 days in custody.
407 days. my lord.
নাম্বার অফ উইটনেসেস আর যদি কম থাকতো তাহলে দিয়ে দেবো বললেই দিয়ে দেবো। হ্যাঁ, তাহলে দুটো গ্রাউন্ডে বলতে হবে, মানে কাস্টডি মোর দ্যান 1 year আর ডেট অফ ট্রায়াল নট ফিক্সড এন্ড 18 witnesses to be present.
may I, lordships?
Yes.
Actually, when the trial court fixed for date for taking proceedings, that time they have preferred this bail
No,
applications.
no, my lord, this is totally wrong. I have the certified copy, my lord.
Your, when I submit before lordships, kindly allow me
Anyway, where is the certified copy of the rejection?
rejection, your lordships.
Yes, by the trial court. No, trial court rejection? Yes. This is by this court. Okay, last page. Yes,
Actually, I will,
last page. Yes, where is this? Yes. Okay, 10/9/2024 was for production and supply of copy. Thereafter, when is the next date fixed? Yes, that is the 3rd October 2024. Copy definitely supplied to you. Now, when is the next date fixed for charge?
so as per my instruction, the next date has been fixed on today, 7/11/24 for framing of charge. And your honor, earlier 2 occasions, your coordinate bench consider all the, they have prayed all the laches and lacuna part of the procedure, but didn't
No, but
establish
now,
that.
you see, after July, I think 3 months have passed, no? After
No,
from
16
23/7, so more than 3 months have passed.
Lordships, thing is that when the matter is taken up for the considerations for the trial, they prefer for bail. So that is the, and your lordships, I am intimated your lordships that our court is highly burdened.
Today will the charge be framed?
Yes. 2 days fixed, but I think a CD is here, your lordships. So court cannot frame the charge without absent of the original CD, your lordships. So lordships,
More than 1 year, last rejection is for 3 months. More than 1 year and 18 witnesses have to be.
lordships, so my humble submission, give a direction to conclude the trial
We
and
cannot.
what.
We cannot. We cannot, more than 1 year in custody, no progress, sorry.
Lordship, due to their part of the fault, your lordship.
What fault?
I think
Trial has not started, okay, after trial, if they take adjournment, definitely that is their fault.
Uh,
Lordships actually give a direction to conclude as because huge quantity. Second time, last occasion, rejection on 23rd, 23rd July 24, your lordship.
progress.
So my submission, your lordship, the huge quantity
Uh,
part by the,
The petitioner says that petitioner renews. The petitioner renews his prayer for bail, which was rejected on May 1, 2024 and July 23, 2024. Stop. He says that he is in custody for 410 days, 407 days. Stop. Even charge has not been framed. Stop. Paragraph. Learned State Council says that today is fixed. Today is fixed for consideration of charge. Stop. The same cannot be done because the case diary is not with the learned trial court. Stop. Paragraph. We are told that there are 18 charge sheet named witnesses. Stop. The petitioner is in custody for more than 1 year, 1 month. Stop. The trial has not commenced. Stop. In fact, there has been no appreciable progress in the trial. Stop. Paragraph. On the ground of delay in progress of trial, we are inclined to grant interim bail to the petitioner and see how the trial progresses. Stop. Paragraph, accordingly করে interim bail দিয়ে দাও। করে next, this order of interim bail shall continue till এখানে কোনো December 20, 2024, or until further order, whichever is earlier. Stop. Place this matter next circuit before the next available circuit bench.
Lordship, my strong objection kindly be noted, otherwise, actually,
যেটা
these are thrice
সেখানে বলো,
type rejections.
it
Lordship.
is submitted that commercial quantity of contraband was recovered from this petitioner. Stop. There is no fault on the part of the prosecution for non-progress of the trial.
Okay. Item number 15. My lord, no CD1 accommodation. 16.
Once again, the investigating officer just contacted me. He has been recently posted in Lava. This was the case of Nakshalbari. So he prayed for 2 days at a so that he can.
Monday.
17. 18. 18.
18 state.
I'm for the state, your lordships.
Female accused. Female accused. Yes.
On the petition, 20 kg, 100 gram of Kajapur. 20 kg is the commercial quantity. And in this case, my specific submission, there is a violation of section 41 of the code of criminal procedure. Now, if my earlier, PRPC, now it is 36 B. Arrest memo, which was signed by the lady constable, member of the regional party. And I covered by your lordship judgment, whether your lordship was looking at that again. On this point.
Forty-one B একটা judgment আছে division bench এ। Bill কি একটা judgment আছে।
Yes, when was the seizure made?
At the time, at about 9:55 PM.
PM.
Independent, at the time of seizure is independent witness. But arrest, no. Same time, it was signed by the member of the reading and the railway station. Populated.
Yes, what do you say?
Other body is also.
Where is the arrest memo? Not annexed.
At page 7.
Not signed by independent witness. Either
Personnel.
signed or not
But
signed.
in several cases, our Supreme Court has cited that the police witness cannot be officially. This is a valid witness, my lord. Huge quantity of gaja has been recovered from the exclusive possession of this petitioner at that NGP railway station platform number 3.
What about this decision? Have you considered this decision? It has dealt with the Supreme Court decisions.
The decision as well as the petitioner is the female accused. How long you are in custody?
Case of September 2020. 12th September.
All violation में several coordinate bills, all of the other coordinate bills I am facing the similar judgment. Many other coordinate bills follow this statutory violation. If there is infraction, there is penalty.
It will be decided at the time of trial, my lord.
I will cooperate.
It is a pre-trial stage, my lord.
No, division bench judgment has decided it while the time of considering bail.
But at the same time, Supreme Court has already
The
fined.
Supreme Court
Which one?
decisions
Which
were
one? Show us.
considered.
Sure. Show us. This division bench has dealt with the Supreme Court decision, sir.
What password can?
Come back tomorrow. That's if you can show a Supreme Court decision which is to the contrary, not considered by this bench, naturally that will prevail.
Madam. Item number 19. 20.
Custody is 545. And at the time of submission of the charge sheet, without evidence, charge sheet has been not. Nursing with the renewal of my application, which was earlier indicated on.
Is what was seized? How much?
Is 0 kg of tablets and 96 bottles and 179 sticks of.
How long you are in custody?
545.
Trial has started.
What is the stage? Charge not framed. Sir?
Lordship's previous 4 bail applications made.
Yes, it is that. I have annexed.
Yes.
And the date last rejection on
Yes, 20 to 9.
22nd July 24 years. Lordship.
Okay, okay.
And total 14 witnesses, your lordships. Huge quantity, your lordships.
Who stops you from convicting him?
Lordships, thing is your lordships, your lower court is overburdened, your lordships.
That is not his fault.
No, your lordships, but
May not be your fault. But that is also not his fault.
it's lordships. But thing is your lordships, the commercial quantity.
এই যে ইন্টারিম বিলটা দিয়েছো দিয়ে দাও
Number of days custody, 545.
হ্যাঁ, ওগুলো তো 545 days. Charge sheet not framed.
Charge not fair.
Charge not framed. Commercial quantity of contraband.
Might amend objection.
হ্যাঁ হ্যাঁ, ওই অবজেকশনটা করবে।
Earlier occasions, lordships, we are facing lots of problems, so why second time rejection, why third time?
না তো ওই রিনিউজ ইজ প্রেয়ার বলবে কিন্তু রিনিউজ, হ্যাঁ ওখানে দুটো রিজেকশন ছিল, এখানে তিনটে রিজেকশন আছে, একটা উইথড্রয়াল আছে আর তিনটে রিজেকশন আছে।
Not this, total four.
Number of days in custody, এগুলো খুব ডেভেলপমেন্টের মধ্যে ধরা হচ্ছে।
Report charge sheet has been filed, is activities in custody for more than 400.
FSL report now filed, not yet. Give our order.
This item was fixed with another. 2023.
We have already passed more than one order, Mr. Ganguly, on this aspect.
Yes. Lordship, in 23 is separate because it's anticipatory.
Very well, let us do 22 first. You have a copy of our order, sir. Try to get it, come back.
Not today.
No. Pass over,
23 also.
pass over. We'll call till 59 and come back.
24.
24.
24?
Yes.
Yeah, Lordship.
Yes. Yes, what was seized?
Heroin, Lordship, allegedly
How much?
5 kilogram approximately, but I have other points. I will not argue on facts. I'll be arguing on the points of law and apply the facts thereafter, Lordship. So my first point is, Lordship, the first thing I want to present before the court copy. My lord is aware.
You are named in the FIR.
Yes, Lordship.
His name is the FIR, Caesar is,
No,
my lord.
Caesar list his name.
Yes.
Sole accused, no?
No, my lord.
5 accused persons.
Joint
6
accused,
accused.
6 accused.
Or 3 have come, 3 out of 6.
Lordship. There was previously, before 2022, there was a guideline, there was a statutory instruction called Act 1 by 88. And the entire seizure process, search, disposal of narcotic substances were done in accordance with that. And subsequently in 2022, the new statutory rule has been enacted, Lordship, and this has replaced the old rule of 1/81. Now, this is the rule, the rule is called Narcotic Drugs, Psychotropic Substances, Seizure, Storage, Sampling and Disposal Rules 2020.
Please, which rule has been infringed?
There are a number of rules that has been infringed.
Which? Sure.
Firstly, Lordship, kindly come to the FIR once, Lordship. In the entire FIR, I have carefully gone through the FIR, Lordship. The rule 3 requires identification. Narcotic drugs, psychotropic substances, and controlled substances. Kindly come to rule 3, Lordship. Rule 3, sub rule 1. The narcotic drugs, psychotropic substances, controlled substances seized under the Act shall be classified based on physical properties and results of drug detection kit, if any, and shall be weighed separately. This drug detection, heroin is something that cannot be identified by bare eyes, with bare eyes, Lordship. a brownish powder, a liquid or semi-liquid substance that has been written in the.
How do you establish before us that there was no drug detection kit?
If there was a drug detection kit, it should have been mentioned by the investigating officer in the entire city. There is no mention about the drug detection kit. Lordship. Lordship, I have other points also. Lordship, are other serious breach are there, Lordship.
So why don't you show us the most serious breach?
Yes, Lordship. This is also serious, Lordship. The identification at the first point of time, the identification was not done in accordance with the law. Thereafter, Lordship, I am coming to Rule 2.
Definition.
No, Lordship. Rule 3, Sub-Rule 2, Lordship.
Yes.
The weighment, Lordship. The measurement that it was the container of the plastic, it was found in plastic bags, different plastic bags. It has to be separately, the separate weighment is necessary under this rule. That was not done. Weight is very important, Lordship. In case of heroin, the small quantity.
Show us a decision that infringement of these rules will render the arrest or the seizure invalid. Show us a
Lordship,
decision.
Lordship, I will. Lordship, I will. I'm coming to that, Lordship.
Come to that straight away.
Lordship, other breaches there, Lordship.
We are assuming there are breach. Show us the decision.
There is a breach of Rule 14, Lordship. There is a breach of Rule 14. Rule 14 requires the test report. Test report has to be. There is.
Yes, we have seen
Yes,
14. This is
yes.
only for expedition. This is directory according to us, not mandatory.
Lordship, it has been held mandatory by coordinate benches of this court, Lordship.
We have seen Justice Bhattacharya.
Yes, Lordship.
We have seen that.
Lordship, I agree. Now, this rule, now I am relying upon a judgment of Noor Aga versus State of Punjab. Judgment of the statutory instructions, Lordship. There.
This is on NDPS Act.
Yes.
On these
Yes,
rules.
yes, Lord.
On these rules.
Yes, Lordship. The statutory, not on the, it is 2008 judgment, but on the old rule, Lordship. The statutory instructions are to be followed strictly, Lordship. When there are statutory safeguards are given, these rules are to be followed. In paragraph number 119, subpara 3 is the conclusion part, Lordship. (319) paragraph 2.
Page 1, para 119.
119.
Page 470.
Yes, Lordship. 119, 470. Last page, Lordship. This was on the old rule, Lordship, but the old rule has been replaced with a new rule. It has the same value, same effect. If there is a serious breach of the rule, Lordship, there is also violation of section 52A, Lordship.
Yes, that is the thing. If you can show 52A
Yes,
is violated,
Can we show?
we can consider.
We can show it. 52, certification will be different. Certification will be. This one, 52. Section 52. Lordship, 52A. Disposal of seized narcotic drugs and psychotropic substances. May I, Lordship?
Show us that there was no compliance with 52A.
Lordship. Lordship, since the charge sheet has been submitted, we are aware of the. We have been served with copies, so I'm mentioning a document from this.
Certification is there.
Certification.
Yes.
There are two certifications, Lordship.
Yes.
The next page also.
One for the inventory,
Yes.
another for the sampling, Lordship. So I have never seen before, Lordship. I have been doing NDPS cases for many years, Lordship. Twice it was produced before the magistrate. Why? I'm asking this question to myself.
On that ground, you're asking for bail.
Kindly go through, Lordship, kindly go
No,
through the
52A,
first
2A.
Yes.
52A, subsection 2,
Lordship.
clause A.
Yes. Where any narcotic drug, psychotropic substances, controlled substances or conveyance has been seized and forwarded to the officer in charge of the nearest police station or to the officer empowered under section 53. The officer referred to in subsection 1 shall prepare an inventory of such narcotics containing such details relating to their description, quality, quantity, mode, packaging, marks, number, or such other identifying particulars, or making or packing in which they are packed. Country origin and their particulars, as the officer referred to in subsection 1, may consider relevant to identify the narcotic drugs, psychotropic substances in any proceeding under this act, and make an application before the learned magistrate for the purpose of lordship. Make an application for the purpose of certifying.
Yes, whether this procedure was followed or not, that you show.
Procedure was followed, but kindly come to the first document, Lord, first certificate. Lord.
First certificate.
It is just the printed format. It is just the printed format. No specific. The above inventory. The above inventory. No, there is nothing above.
And list of some.
I certify the above inventory. There is a privacy.
Mr.
I am
Mr.
coming
How
to
long, much longer shall we hear it?
5 minutes more, Lord. 5 minutes more.
Other matters are there, please
No, sir,
kindly
give me-
consider.
Give me 3 minutes. Above, there is nothing above. Above, certifying the above inventory, there is nothing, Lordship. And kindly come to the Lordship, second certificate, Lordship. The second certificate.
So
that
for
is the-
list of samples drawn is in presence of the magistrate.
Subsequently, it is there is another certificate, Lordship.
Certify the above inventory and subsequent. Any magistrate component. Application. Have been certified for the season.
Again, there is a violation of Rule 11, Lordship. The mixture was not done. It has to be mixed together before taking samples. That was not done, Lordship. Rule 11 there is a violation, Lordship. Kindly come to Rule 11, Lordship. The seized substances in packages or containers shall be well mixed to make a homogeneous mixture or representative before the sample in duplicate is drawn. That was not done in the, it has been mixed up in equal proportion before the magistrate, and then sampling has to be done. That has not been done. That is clear from the report, certificate of the learned magistrate.
Very well. 3 kgs of heroin. 5 kgs.
6 people are there, Lordship.
6 accused persons.
Yes.
3 out of 6 accused persons have approached us for bail. Stop. 5 kgs of heroin, bracketed, much beyond commercial quantity. Right, it was seized from the joint possession of the accused persons. Stop. How long are you in custody?
Joint possession, it's not right, Lordship. There are 2 seizure lists. How can there be 2 seizure lists from the same transaction?
How long are you in custody? How long are you in custody?
8 months.
Stop. The petitioners say that they are in custody for 8 months. Stop. They allege breach of several provisions of the EWA, including rules 3, 11, 14 and 14. Stop. Paragraph. Learned state advocate, while opposing the bail prayer, says that there is sufficient incriminating evidence against the petitioners. Trial has not started, Mr. Charge not framed.
Production, next 86 production.
Production lordship, trial cannot be commenced because one of the co-accused is absconding lordship. Out of 6, one is absconding, so there is no.
Charge is yet to be framed. Stop. Paragraph. We have seen the material in the case diary. Stop. In view of the restriction in section 37 of the NDPS Act, we are not inclined to allow the prayer of the petitioners. Stop. Paragraph. As regards the alleged infraction of the provisions of the rule 10 number, comma, we are of the view that the same, the view that the said points involve mixed questions of fact and law and may be urged before the learned trial court. Stop. Paragraph. As a result, this application fails and is dismissed.
Wait for a minute.
Item number 25.
Number 25, I think that the one of the city has. Actually, this is the same case as item number
Oh,
3. But the petitioner is in custody for more than 530 days. But she lastly on 19/11/2023, charge sheet has been framed.
charge sheet has been framed.
File. Yes, where is the rejection order of the trial court? Last page.
Before High Court, this is your first application.
It's not, I have not this.
আচ্ছা কোথায় গেল লাস্ট এই যে
ও অনেক মানে একজন absconding আছে, ঠিক আছে? তার জন্য
What was seized?
Lorships, a huge quantity of ganja.
How much?
223 kgs.
223 kgs of ganja.
And the Lorships, a huge quantity. And one of the.
Problem is huge number of days they are in custody.
I understand, but Lorships, if I Lorships, I
বছরের উপরে
report from the trial court. Lorships.
500 কত দিন?
500 কত 3 বছর হয়ে গেছে, আর ট্রায়ালের কোনো ইয়ে নেই, প্রশ্ন সেটাই একটা করে।
Lorships, think is your Lorships, the
Sir,
WPA issued against one accused person.
sir,
And
whatever it is, we have granted interim bail in a case where for 400 days one is in custody. How can we have double standards?
Lorships, think is your Lorships, if your Lorships see the conduct of the trial court, if we'll file a report before the trial court, maximum time of cases,
Yes.
the when is taken up for evidence, the defense counsel paid for time. So here in the.
No, you see, year of WA is pending.
Lorships, huge quantity your Lorships, so give
ওই
it
interim bailটা করে দাও।
within the
এটা-
within 6
এটা
months. we
renewal
complete
নেই
it.
কিন্তু। Praise for bail, huh? We can't give that direction. Supreme Court.
And another thing, your Lorships, it is a practice of the lower court that when is a matter for evidence, everybody file, when after refusal the bail from the higher court, high court,
Sir,
they
these
again
are
paid
the-
for the bail applications.
These may be systemic delays, but then for that, the under trial, the accused person cannot be made responsible. Burden on the trial court, we understand. It is up
So
to the.
it's not that it is at the very nascent stage, okay, everything is complete, near about 1.5 years, so all these things are to be considered.
Article 21 is the most important thing now, the Supreme Court has said.
I understand your Lordship, but thing is your Lorships, the when the date has been fixed for evidence in lower court, they prefer bail applications automatically.
No, we consider those things, okay,
Yes,
where there is the intentional
That-
delay.
that is- yes.
If there is intentional delay on the part of the accused, definitely,
But-
we don't condone.
From the CD, it is not reflect.
No, from the order
Lower court
sheet,
proceedings, your
order
Lordship.
sheet.
Item number 26.
26, diary has yet not arrived.
Tell us when?
put it on Monday.
47.
Admittedly, we are 10 kg.
10 kg.
With CFSL charge sheet submitted within time, but it is 10 kg of that.
Sole accused.
So like, just
How
No,
long
anything
custody?
recovered from this person?
10 kg of that.
No, then he has surrendered, you see, Parrot 7, at the time of surrender, how it can be recovered? Yes,
Thereafter, issue. Thereafter, he again surrender. Now he is in custody about more than 108. 10 kg of custody.
Then you breached condition of bail.
Yes.
What no? No, what you will do, we are not interested. What you have done, we are interested in. Bail condition breach করেছে, দেখুন না, ওটা কি bail condition breach করে surrender করেছে, arrested হয়। আরে দিয়েছে।
Voluntary surrender.
He was a good boy, he voluntarily surrendered. Yes, sir.
But with some stringent conditions.
Yes,
that
yes, yes.
He will appear in the trial court.
That is always there. If you want some more conditions, tell us. The petitioner was granted bail, aage dekho. 10 kgs of ganja, bracket intermediate quantity, bracket closed, was allegedly recovered from this petitioner, who is the sole accused. Stop. He was arrested. Stop. He was granted bail by the learned trial court. Stop. He says that because of some personal difficulty, he could not attend the trial and was again arrested. He is now in and was again arrested, and warrant of arrest was issued. Stop. He surrendered before the learned trial court. Trial court. Stop. He is in custody now for 110 days. Stop. He prays for bail. Paragraph. Learned state advocate opposes the prayer and says that once he has breached the conditions of bail, he should not be shown any leniency. Stop. However, he admits that intermediate quantity of contraband was allegedly recovered from this petitioner. Paragraph. Since intermediate quantity of contraband item is involved, the restrictions in section 37 of the NDPS Act will not apply. Stop. We take a lenient view and are inclined to accept the petitioner's case that because of personal difficulty, he could not attend the trial court. Stop. We also take note of the fact that he voluntarily surrendered before the trial court. Stop. Paragraph. On an overall assessment of the facts and circumstances of the case, we are inclined to allow the petitioner's prayer. Accordingly, he will reside within Kuchbihar. আর বাকি যেগুলো আছে সব report to the IC Kotwali police station once every week. Yes, Mr.
Case of the
Member.
prosecution in a nutshell. If Lordship sees page 11, that is the written complaint, that a private vehicle was apprehended along with some contraband articles, opium. Lordship kindly sees page 11, 8th line from top. May I read, Lordship? On 3/3/2024 at 14:15 hours, received a source information that one Mahindra Scorpio such and such coming from Assam side carrying some contraband drugs illegally inside the vehicle. Accordingly, I informed the matter to OC Barubisha OP and diarized the matter while Barubisha OP GD entry number such and such dated 3/3/2024. So, as per Lordship, section 42 1, the matter was taken down in writing. Now comes section 42(2). Within 72 hours, it is a mandatory duty of the officer to intimate his superior in writing. As because, Lordship, the intention of the legislature as well as the several judgments of Apex Court, we have the judgments. The non-compliance of section 42(2) vitiates the trial event because the intention was,
NDPS.
Lordship, the intention was so that the inferior officer does not have any power or chance to frame someone, and the search and seizure and arrest comes into within the knowledge of the superior officer. So can he can have a guidance over the matter. Lordship, section 42 NDPS Act 1, if I may read, Lordship, any such officer, such and such rank, then taken down in writing that if he resolves to believe that from personal knowledge or information given by any person and taken down in writing that any narcotic drug or psychotropic substance or controlled substance in respect of which an offense punishable under this act has been committed, or any document or such and such is kept concealed in any building, conveyance or enclosed place, may between sunrise and sunset do such and such things. Then comes 2, where an officer takes down any information in writing under subsection 1 or records grounds for his belief under the proviso thereto, he shall within 72 hours send a copy thereof to his immediate official superior. Now, Lordship, in this regard, I have annexed a coordinate-based judgment also, which is based upon 2 Supreme Court judgments. I have the copies of those judgments also. Lordship, kindly see page 27 of my petition, Lordship. The relevant portion is on page 30, starts from para 15. The Supreme Court Bhutta Singh judgment was referred to. Then para 16, section 42 of the NDPS Act relates to the power of entry. It's the act. Then 17, Lordship. 17, 42(2) continues the statutory mandate on the officer who intends to enter the search of a building, conveyance or enclosed space between sunrise and sunset to intimate his immediate official superior. That ground is there. And 18, in the present case, as in our case also, the prosecution has submitted that the LS secret information received by the prosecution was written down by GD General Diary entry on such and such by this task force, which was subsequently intimated to the superior officer. In our case also the same happened. Then, Lordship, whether the GD entry amounts to written down in writing or not, para 19. Para 21 is very important, Lordship, where Supreme Court says that no GD can be done because it cannot be used as evidence, and no copy under 207 can be given. So it cannot be used. And Bhutta Singh's judgment is also there. I'm handing up the judgments also, Lordship. Bhutta Singh. So I have given the Bhutta Singh judgment, Supreme Court, para 14, if Lordship kindly sees. Relying upon another judgment of Jagraj Singh alias Hansa, I have that judgment also.
Which portion?
For para 14, Lordship, starting with in Jagraj Singh alias Hansa, the facts were more or less identical. In that case, the vehicle was not a public transport vehicle. So in our case also, it's a private vehicle. After considering the relevant provisions of the and some of the decision of this quote, including the decision of Colonel Singh, it was observed. What section 42(2) requires is that where an officer takes down an information in writing under subsection 1, he shall send a copy thereof to his immediate officer's senior. The communication of which was sent to the circle officer was not as per the information recorded under exhibit such and such. Thus, no error was committed by the High Court in coming to the conclusion that there was a breach of section 42(2). And Lordship, para 15, 16. Para 16 also, Lordship. It is an admitted position that there was total non-compliance of the requirements of section 42 of the NDPS Act. 17, the decision of this court in Colonel Singh, as followed in the Jagral Singh, is absolutely clear. Total non-compliance of section 42 is impermissible. Here is total non-compliance, Lordship. It was not even communicated to the
42(2) was not complied with. That would be easy to 42(2) compliance. 42(2) compliance need.
it is a mandatory provision. It has to be complied.
Then our hands are tied. What can we do? Ashok. What was recovered?
Lordship, opium.
Acha.
Opium.
How long you are in custody?
Lordship, I was arrested on Lordship,
Hard of March.
Lordship, March,
Hard of March.
249 days. 8 months.
The petitioners say that they are in custody for 249 days. Stop. This is your first prayer. Fresh.
Lordship.
Stop. They pray for bail on the ground of non-compliance with the provisions of section 42(2) of the NDPS Act, which reads as follows. 42 দিয়ে দেবে এই বইটার পেজ 32 তে আছে paragraph. Learned Counsel relies on the coordinate bench decision of this court in the case of
Page 27, Lordship. Abdul Rakib.
petition page 27 এ আছে দেখে নিও Abdul Rakib versus State of West Bengal bracket এ CRM টা দিয়ে দেবে NDPS number টা দিয়ে দেবে page 27 থেকে in support of his submission. Stop. He has also placed before us the decision of the Honorable Supreme Court in the case of Bhuta Singh and others, etc., reported at such and such. Okay, sir. Paragraph. Learned advocate for the state, in his usual fairness, admits that there was non-compliance with section 42(2) of the NDPS Act. Paragraph. We see from the judgment cited before us that section 42(2) of the NDPS Act has been held to be a mandatory provision. Stop. Non-compliance with the said provision is liable to render a conviction bad. Stop. Paragraph. In that view of the matter, since admittedly the provisions of section 42(2) of the NDPS Act were not complied with, the restrictions in section 37 of the NDPS Act stand sufficiently rebutted. Stop. We therefore allow the petitioners days for a prayer for bail accordingly.
Grateful, Lordship. Lordship, I for the petitioner.
State,
The charge sheet filed without FSL.
Monday,
Lordship, then,
you were in
Lordship,
Calcutta,
can it be fixed on Monday?
Monday. You have to go to Calcutta?
30, 31, 31.
31? Not today or Monday?
32. 32. 33.
Not today.
33.
সোমবার অনেকদিন চলে গেছে।
34.
সোমবারে অনেকদিন চলে গেছে। যা বলতে হবে, আমি তো 4:30 বেশি বলবো না।
35.
Monday. বারবেলার এফেক্ট পড়ে গেছে দেখতে পাচ্ছ তো।
37.
Monday.
38. 39.
38, what happens? Not today, not today. No, not today means Monday. Hey, 38 Monday.
39.
40 and 42 my lord.
যদি ঠিক মতো করে তুমি তোমার কাছে না হয়ে অনেক জনের লাস্ট সোমবারে সামাল দেওয়া যাবে।
হবে।
Yes,
But for item 40 and 42 my lord, arising out of same PS case.
very well.
Mr. Misa will apprise your lord.
Are you ready, Mr.?
Yes, yes.
Yes. Tell us.
There are two petitioners. The father and son. And the complaint is illegal. There is a dispute, but the defective complaint posting complete sheet and boundary.
Oh, this is not Gaja.
302.
And there was a dispute occurred, but it was FIR for it. Written complaint. Is 9. It was assaulted by 3 and 2.
Page 9.
5. 9.
Yes. You said 2 petitioners, there's only 1 petitioner. I see. Yes. Oh, 302 has been added.
Yes, my lord. My lord,
I'm saying,
the deceased victim was badly throttled.
but
She was admitted. Thereafter, the my lord, aged person died on the next day. Kindly have the PM report, my lord.
That- Yes, let us see the PM report. How long are you in custody?
there is a allegation that Calcutta, he thereafter he himself lost this written complaint.
Okay, the victim.
Victim lost it. Thereafter he came to the house and thereafter he was after next day he was
He or she?
in hospital.
Victim was he or she?
He himself lost this complaint. Thereafter next day admitted in hospital.
No, the date of incident is 7th of March, okay?
Yes, ma'am.
Yes, and Hospitalized on which date? Where is that?
My lord, he died on, my lord, 8th of March, my lord.
Okay,
Same
so-
report, page 64. Kindly have a look, my lord.
Victim is Robindra Chandra Kundu.
Yes, my lord.
He himself was this contract that.
Page 70?
My lord, 64.
Page
64.
64.
Cause of death, my lord. Can you see the cause of death? Injury is also mentioned. There's no injury.
এই দেখুন এটা কি লিখেছে
Nothing.
কার্ডিয়াক ইনজুরি স্টোমা instead of doing
He died other reason. That is the opinion of the doctor.
direct or indirect trauma
Chest wall. জুড়ি মাত্র করেছি, গলাটিকে ধরেছি, বুকে মেরেছি।
প্রথম দিনে হয়তো ছিল না আর কি। আচ্ছা এইখানে যেটা যা হয়েছে অস্ত্র টস্ত্র কিছু ইয়ে নেই, হাতাহাতি হাতি মেরে ফেলা তো যায় মানে কোয়েশ্চেনটা হলো আর উইটনেস যেহেতু ট্রায়াল করতে চাই সেটা হয়তো 304 হতে পারে পরে পুরো অতটা ইয়েতে নাও যেতে পারে। কতদিন আছে
Yes, 164 statement of
My lord,
any neighbor,
Page 58 and 59.
58 and 59.
Eyewitness.
Yes, my lord.
But then the victim himself lodged this complaint. That will carry a lot of weight. No, it is quite possible to kill somebody with bare hands.
Cause of death, my lord. This is not the doctor.
How long are you in custody?
Charge sheet submitted.
Acha,
Both
এই যে,
cases
এই যে।
person- There is no injury. Injury is painful, but 325 charge sheet.
আমি কাজে গেছিলাম তখন মালিকের প্রথমত 8টা ফিটিং খুঁজি মঙ্গল চৌহান আর সুরাজ চৌহান তখন রবি কে ধরে তাকে তার বুকে বেশি মারে ও আঘাত করে পরে আমি জানতে পারি যে সে হাসপাতালে মারা গেছে
বললাম না বুকে বুঝি হয়েছে।
তাহলে তাকে মানে বাবা ছেলে দুজনেই ইনভলভ দুজনেই আর সেখানে কি আছে
Charge not framed.
এই একই জিনিস এটা কি
Which is the next date?
Yes, what are the age of the petitioners?
Mongol Chauhan. 43 years old and present 40 is 20 years old.
20 years boy is which one?
Other so both
তাহলে বয়স কি 20 বছর বয়স থাকলে কি ইয়ে করা যাবে যে 20 বছরের ছেলে বাচ্চা ছেলেটা মানে বাবা ছেলে তো 20 বছরের ছেলেটা ওটাকে কি একবার ইয়ে করা যাবে সেটা হচ্ছে ব্যাপার 20 বছরের ছেলেটাকে
ইয়ে করে বেল দেবে
তোরই ইনভলভমেন্ট আছে
দুজনে মিলে পিটিয়েছে, এমন পিটিয়েছে, কার্ডিয়াক ইনজুরি হয়েছে, কি পরের দিন মারা গেছে।
এফআইআরটাও করেছে এমনকি তার ওই এফআইআরটাও এক ধরনের টাইম ডিক্লারেশন করতে
ছিল তো হয়নি 245 দিন হয়েছে, আর বছর হয়েছে। সুতরাং পরে যদি
ঠিক আছে
charge sheet submitted under 304. There is no injury.
Oh, charge sheet submitted under?
304, I think.
Oh.
Kindly consider PM doctor opinion, my lord. PM doctor opinion, my lord. Kindly, there is no, they did not saying that proximate cause of death of the assault, my lord. Kindly see, there is no injury.
Cardiac injury because of the blows on the chest.
My lord, kindly, who assault?
Both the persons assaulted, so both the persons bail rejected. Lekho. The come back if there's undue delay, come back. The petitioner, they should have been more responsible. The petitioner says that he is in custody for 249 days. Stop. He had no intention to kill the victim. Stop. There was dispute between the victim and the petitioner petitioner's family, petitioner's family, in respect of land, stop. There was a scuffle between the victim and the petitioner and his father. Suraj is the father or son? Between the victim and the petitioner and his father. Stop. Charge sheet has been submitted upon completion of investigation. Stop. Further custodial detention of the petitioner is unnecessary. Paragraph. Opposing the prayer for bail, learned state advocate draws our attention to the postmortem report, as also to statements of eyewitnesses recorded under section 164 CRPC. Stop. The same prima facie implicate the petitioner. Stop. Paragraph. In view of the gravity of the offense and the prima facie incriminating material against the petitioner, we are not inclined to allow his prayer for bail, at this stage. Dismissed. Number 42 টাও same হবে, খালি এখানে ওইখানটাই হবে scuffle between victim, the petitioner and his son. ঠিক আছে? At this stage. 41 state.
My lord, the allegation is under section 302 IPC. My lord, in brief, the case of the prosecution is that I have killed my wife and went to the police station and confessed my guilt before the police officials. That is the gist of the prosecution's case, my lord. But my lord, the petitioner submits that it is not true, my lord. Milord knows better than me in terms of section 25 of the Evidence Act. Any statement, confessional statement given before the police official has no evidentiary value. Now, my lord, whether I was placed before any judicial magistrate for confessional statement, the answer is no, my lord.
Where was she killed? How was she killed?
My lord, the actual case is that I am a labor. If it is appeared from the FIR, my lord, that from the love affairs, our marriage was occurred 7 years ago. And from that, my lord, the victim's family, that is my wife's family, was in rivalry with me. Now, my lord, on the date of occurrence, my lord, I came to from the Cha Bagan. I am a tea garden labor, my lord. I came from the tea garden and saw my wife in such condition. I called my relatives, in-laws.
No, saw your wife in what condition?
She was in dead condition, my lord.
You found your wife to be dead?
Yes, my lord. And that time they were pressurizing that I have committed that crime. I went to the PS.
How was she killed?
My lord, the allegation is that by strangulation. Strangulation with some rope string, my lord.
Yes, where is the 164 statement?
Appeared to the police station and surrendered confessing his crime.
No, my lord, actually I went to the police station to lodge the complaint, my lord. But I was detained. Subsequently, from the family of the my wife, a complaint was.
Okay, where is that FIR? FIR, first of all, FIR.
FIR is page 1.
Page 1.
According to you, who could have killed your wife?
My lord, few days ago, the mother of my wife died, and there were some property disputes, and it is transferred from the 161 statements, my lord. There are different angles, my lord, and 161 statement to which I would like to rely, my lord.
ভিডিও বাড়িতে অনেকবার করেছিল। ২ তারিখে আনুমানিক ছটায় জানতে পারি বিনোদ বাড়ি আমার গলায় রোগী খেয়েছিল। ফোন করে পরবর্তী আমার দিদিকে কলকাতা পাড়া হসপিটালে নিয়ে গেলে ডাক্তার তার মানে ওকে মেরি হসপিটালে।
There is one.
Yes, let us see the postmortem report.
Page 99.
My lord, there is 161 statement of the local panchayat member who is the family relative of my in-laws.
How long are you in custody?
My lord, I am in custody for 346 days. My lord, charge frame on 23rd April. 5
Okay,
days
page
have been given,
99.
not a single witness has been examined, my lord.
How many witnesses are there?
My lord, as per charge sheet, my lord, 18 witnesses. My lord, I have little children, old mother, there is no one to talk to them.
I will give you chair. As proceeding. As an anti-mortem. Doctor ইয়েটা কোথায়?
Yes, he was taken to hospital. Anyway, hospital medical report.
Broad date করে। তাকে কি অবস্থা নিয়ে গেছে?
No, he was taken to the victim. Yes. Broad dead.
Is what is there to incriminate this petitioner?
Self was going to the police station and confessing.
No,
the
but
crime
that is
of
not a
the-
judicial confession, Lucy.
Lordship,
That
That
is not
is
a
not-
judicial.
that is-
You have to establish the case.
Page 24, my lord. The statement of the de facto complainant, that is the sister of the deceased victim.
Page 24.
Yes, that will be the same as the FIR, written complaint, what she has said.
Assumption.
Of? What resumption?
No, that is 304B you want to say. But here it is 302. No, period of detention is almost 1 year.
Almost 1 year. 346 days.
346 days, my lord.
Trial has not yet.
Charges framed on
Charge-
23rd.
April.
Charge framed on 19th of September 2000.
No, my lord, I have annexed the order copy in my petition.
Where?
Page number. Page 15, my lord.
Yes. P1,
Yes, my lord.
23rd April,
April.
23rd April. 18 witnesses, 23rd April, the charge was framed. May, June, July, August, September, October, November.
5 days, my lord, have already.
At this rate, it will take 5 years.
Anyway, there is no chance to abscond for this person. And not to, he cannot even tamper with the witnesses.
Right.
Everything is recovered.
Issue. The petitioner says that he has been falsely implicated. Stop. The prosecution case is that the petitioner killed his wife and then went to the police station and confessed. Stop. The petitioner says that such a confession is not admissible in evidence. Stop. There is no incriminating material against him. Stop. He is a daily laborer working in a tea garden. Stop. On the concerned day, he returned home and found that his wife was lying dead. Stop. He had in fact gone to the police station to lodge a complaint when he was detained and then arrested. Stop. Paragraph, learned state advocate, comma, while opposing the prayer for bail, comma, draws our attention to the postmortem report. Stop. He also shows us statements of witnesses recorded under section 161. 161 CRPC. Stop. Paragraph, on an overall consideration of the material on record, comma, prima facie, we do not find anything which implicates the petitioner. Stop. He is in custody for
46 days, my lord.
46 days. Stop. Charge was framed on April 22, 2020, 23, 2024. Stop. Witness action has not yet begun, even after 7 months, almost 7 months. Stop. There are 18 charge sheet named witnesses. Stop. There is little chance of an early conclusion of the trial. Stop. We also see no real possibility of the petitioner absconding or tampering with evidence. Stop. Paragraph. We are therefore inclined to allow his prayer for bail accordingly.
Grateful, your lord.
Don't leave that কি বলে কোথায় থাকে?
Jurisdiction of the court.
Jurisdiction Nagaragata case, my lord. Grateful, your lord.
Report once every week to the local police station.
My lord.
ঠিক আছে, usual condition যেগুলো।
Grateful, my lord.
43 things on market.
43?
Monday.
Monday.
44 not today. 45 not today.
Just as a matter of interest, are these for astrological reasons? No. No. That's right.
You see, there are so many matters on Monday.
Some Monday will provide.
Otherwise, let it be Friday or Tuesday.
Friday.
You know, there's so many cases, there can be a court on Saturday or Sunday. There's so many cases.
Item number 46 is praying for one day admonition.
One day, not today.
47. Earlier 326, 307. Now it is 118, 2 and 109 of the PNS. 307 and 326. Earlier. The charge is submitted. And a custody of 117. 326 allegation of.
How serious is the injury?
Stitch is done, but then you have the hospital and and he was discharged on.
Next day, what was the incident?
Incident was sending some questions in front of the shop of the first complainant, warrant plus assault.
Since
Sending some questions, solid waste.
solid waste.
57.
এইবার
So injury not grievous.
What injury was the next?
দোকানের সামনে ফুটপাতে তখন দোকান আছে।
সামনে আমার তখন আমার জলটা যেত তখন বাইরে বাইরে করতে তখন কি হয়েছে তখন তারপর আমাদের আমার গলায়।
What kind of a person you are? You carry a da in your bag all the time. Any recovery? Yes.
What was recovered from this person?
Da.
These are list
From his house.
Which page?
Which page? There is a back.
ভয় থেকে ভয় লাগা থেকে কেটে গেছে, এটাও হতে পারে। আপনাকে ঠেকিয়ে গলায় ঠেকিয়ে অনেক কিছু হুমকি দেয় এবং হয়েছে হুমকিও হয়েছে, এটাও হতে পারে। ইঞ্জুরি তো আছে, ইঞ্জুরি তো হবেই। আর যদি একা থেকে বাড়াবাড়ি যদি করতে গিয়ে তো খাবে, কিন্তু পরে তিনি রিকভারি তো হয়েছে কি না, রিকভারি হবে। ওই যে বললাম তাদেরকে হুমকি দিতে যাবে, হয়ে গেছে অনেকদিন কষ্ট করে নেচার অফ ইঞ্জুরি পিরিয়ড অফ ডিটেনশন।
Wooden handle, small da. Anyway, he will issue. The petitioner says that he had no role to play in the alleged incident. Stop. He has been falsely implicated. Stop. There was heated exchange of words between the petitioner and the victim who own shops in the same locality. Stop. He is in custody for 117 days. Stop. Charge sheet has been submitted. Stop. His continued detention is unnecessary. Paragraph. Opposing the prayer for bail, comma, learned State Council draws our attention to the postmortem report. Stop. The
Postmortem report.
sorry, the injury report, comma. The injury does not appear to be grievous. Stop. The offending weapon being a wooden handle, small da, D-A-H, da, within inverted comma, appears to have been recovered from the house of the petitioner. Stop. Paragraph. Having considered the facts and circumstances of the case and the material on record, as also the gravity and nature of the alleged offense, and keeping in view that investigation is complete and the petitioner is in custody for about 4 months, comma, we are of the opinion that further custodial detention of the petitioner is not necessary. Paragraph accordingly. Don't leave. What? Don't leave what? Which jurisdiction?
Jurisdiction of the court.
Jurisdiction of the trial court. Why Wednesday? No, come on Tuesday, yes.
Tuesday.
Wednesday is a penultimate day. Come on Tuesday. Tuesday. Monday. 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 Monday.
That is why we are keeping it on Tuesday.
Tuesday you will not be there. Then we will find Wednesday.
Wednesday.
I remember him. Train for not today.
51. 51 on that.
My lord, I am for the petitioner.
Yes.
Shubho Bijaya first.
Shubho
Better late than never, my lord.
Shubho Deepavali.
My lord, and Shubho Chhath Pujo.
Passover. State is praying for a Passover, Mr. Mukherjee.
Well, then make it not then Monday, my lord, if possible, because I won't be after 2 o'clock, my lord.
Monday, Monday.
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 Grateful, man. Grateful.
Why are you on the virtual mode, Mr. Mukherjee? The weather is beautiful here.
Good weather, my lord. Then I'll try to come on Monday, my lord.
Very nice. Try.
Thank you, my lord. Grateful, my lord.
For not today, kindly fix it on 13th, Lordship. Mr. Rajdeep Majumdar appearing in this matter.
53. 54.
54, Lordship, kindly fix it on 13th, Lordship.
55.
Yes, ma'am, for the petition.
55.
55.
55 state. 55. Not today. Huh? Oh, 54 is 13th. And 55 is not today.
Not today also.
56. 57.
57, my lord, I am praying for 1 day application.
You are for the petitioner?
I for the petition.
58.
Kindly fix for Monday, my lord.
59.
Second call for
1 day accommodation.
Monday.
59.
One day accommodation মানে তো
I am for the petitioner.
Three,
I am for the petitioner, my lord.
state.
My lord, this is the similar matter with item number 25. Today, he also enlarged on bail, co-accused.
25.
25.
25 is
Same matter.
25 এ তো কোনো অর্ডার হয়নি?
25.
Oh, I see.
ওর নামটা কি?
is the same case of
Same
25.
case, Same case.
Same case.
MD Aslam. And
No,
that
that
was,
bail.
oh, Nitish Kumar. Co-accused.
3 days.
হিন্দিতে সই করেছিল।
Both
This is the same
For 33 days, charge not framed.
Charge not framed? Yes, my lord.
Yes, joint possession,
Joint
Yes.
action.
same order, শোনো। কোন আইটেম দিয়েছিলাম? 25? প্রথম কোনটা দিয়েছিলাম? Which was the item number?
25. my lord.
Sure.
Yes, my lord.
25 এর অর্ডারটা টাইপ করে দাও।
Same case কি?
এই কেসটা এই
Same
কেসটা এই
case.
কেস
Same case diary কিনা তুমি জানো?
So 25 is the same case.
Same.
তাহলে 25 এর অর্ডারটা একটু
25
দেখাবেন।
এ যে অর্ডারটা হয়েছে,
এটা দেখাবেন।
হ্যাঁ। ঠিক আছে।
দুটো একসাথে প্লেস করে দেবেন দুটো order।
Interim bail to be placed before the next circuit bench.
Lodge.
Solely on the ground of delay.
Lodge.
Grateful.
Lord, in item number 4, I am for the petitioner. Lord, the petitioner is a lady, my lord, she is suffering from syphilis. Lord, we are yet to collect one medical document, my lord. Let the matter will appear on Monday.
Lodge.
Item number 5.
But in 5, my lord, I am for the petitioner. My lord, the learned. Lord, this is a case where under the provisions of the NDPS Act, but very interesting case. The NCB personnel, my lord, on the basis of a secret information, they went to the place of occurrence, taking BSF people along with them.
Sir, then it's 12 o'clock. We'll take it up once we come back.
Well,
Okay.
My lord, the instant bail application, my lord, arises out of offences under the NDPS Act. My lord, allegedly the prosecution was conducted by the NCB.
Give me one. You please come here. Come here.
The case starts as the NCB officials got a tip that huge quantity of Raja was stored in a place, and my lord, they goes for a raid. Now, my lord, I'll take your lordship to the complaint directly, my lord, how the entire thing has happened, my lord. Lord, it starts from Annexure P2, page 12. Lord has found it. Lord, the relevant para is page 13, from paragraph 3 onwards.
Yes.
Lord, that a team of NCB officers and a staff, as detailed, moved out from 75 Battalion BSF Gopalpur, Kuch Bihar at about 3-5 hours on 26/8/2023. Lord, date and time is very important, Lord, and reached at Hindustan Mode, Kuch Bihar at about 4-5 hours on 26/8/2023. And as detailed, 75 Battalion BSF team of Gopalpur, including lady official, joined at this same Hindustan Mode. From there, NCB moved with the BSF team, which was led by Sri Pushkar, Assistant Commandant, and reached at village Pedbhata on 26th August 2023 at 5:15 hours. Now, my lord, from this line, my lord, it is clear that this person was leading the entire team, Pushkar, Assistant Commander. My lord, may come to the next page then. Yes, my lord, next page, para 6. It says that then the team revealed the secret information available with them and asked his cooperation during search of his house premises. My lord, he is the petitioner before your lordship. The house consisted of RCC and corrugated tin shed house. Total 4 rooms with 1 corridor veranda, 1 kitchen and 2 cattle room is there. Thereafter, of Hiro Sarkar was given notice under section 50 of the NDPS Act 1985 as amended in writing under proper acknowledgement. And he was duly explained verbally about his legal right to be searched before any magistrate or gazetted officer duly empowered under the NDPS Act 1985. And also that he could search every member of the team and independent witnesses before commencing his own personal search. In the same notice, he was also intimated that Sri Pushkar, AC, Assistant Commandant of 75 Battalion BSF Gopalpur, Kuch Bihar, who was present with the team, is a gazetted officer. Then, Hiro Sarkar replied in writing and stated that there he is ready to be searched by the team present there and his personal search can be conducted by the raiding team. Accordingly, his personal search was done in front of the gazetted officer. So, my lord, the person who was leading the team, who was a member of the raiding team, was leading the raiding team, has acted as a gazetted officer while conducting the search and seizure under section 50, my lord, that is totally contrary to the law laid down by the Supreme Court in state of Rajasthan versus Parman. Yes. My lord, thereafter, more interesting things. My lord, may come to page number 16. Continuation of the complaint, paragraph 12. It says that the search cum seizure procedure was completed at about 8:50 hours on 26th August 2023 without causing any injury or damage to any person or property. No religious sentiments were heard during the seizure procedure. Thereafter, a search cum seizure list was prepared by maintaining all legal formalities on the spot and using the official laptops, portable printer, UPS and other equipments that the NCB and BSF team had brought with them. The seizure proceedings were also videographed by Sri Nitesh Kumar Rai, Sepoy, NCB Kolkata, as requested by the seizing officer, and the video has been stored in DVD CD, which has further been kept in a green color envelope sealed with lac and marked as DVD CD and bears the signature of Hiro Sarkar, seizing officer Sri Kajol Mandal, so-and-so, independent witness and commandant Sri Pushkar. Copy of the search cum seizure list is annexed. Now, my lord, may come to the seizure list. Page number 29.
Yes.
My lord, it says place searched house premises of Hiro Sarkar, so and so, son of so and so, resident so and so. My lord will find in the entire seizure list, it is a 2 pages seizure list, the signature of the accused is nowhere. It has been signed by Inspector Vivekananda, one Sujit Das, who is supposed to be the independent witness, one Shathi Mojumdar, and the officer conducting the search. But the accused person's signature has not been obtained in the seizure list.
Yes.
Now, my lord, next, my lord, may come back to the complaint again. My lord, page 16. What happened thereafter, after the search and seizure?
Yes, which page?
Page 16, my lord.
What are you driving at? I'm still not followed. What are you driving at? I have followed that permanent case I have followed.
Yes.
Apart from that, what?
Now, my lord, they say that they have conducted the premises, they have found Gaja, search conducted, seized. And after that, my lord, they have given a notice, they have not obtained any signature. They have given a notice to the accused person under 67 of the NDPS Act and asked them to accompany, asked them to come to the BSF camp for further interrogation. As per them, the accused person has said that I do not know where the BSF camp is. You please take me along with you. And thereafter, he was taken, and in the evening, Milord, on the same day in the evening, he was arrested. Now, Milord will find the seizure list also. There is a blatant violation of section 41B. Milord, the independent witness, who they have said that he has witnessed the entire proceedings, Milord, he has turned hostile, saying that I went out to answer the nature's call. They have taken my signature forcefully. They have thereafter they have taken me to the BSF camp. They have kept me there under confinement for the entire day and have taken my signature.
Trial has started.
Yes, this is the evidence of the independent witness, my lord, who allegedly has witnessed the search and seizure.
The independent witnesses have turned hostile.
Yes.
And how long are you in custody?
My lord, almost 1 year, 3 months now.
My lord, out of 10 witnesses, 3 have been completed, 7 remain, 7-12 is the next date.
Yes. How will you establish?
My lord, you will get acquittal.
Yes, but then prima facie we have to see why should he be in jail for even one
My
extra
lord, let
day?
him complete. I will let him complete.
Independent witness is mandatory. Anything more?
My lord, obtaining the signatures in the seizure list is a mandatory requirement, and that primarily shows that the accused person was present at the spot when the entire exercise was undertaken. Now, my lord, I was never present when the alleged search and seizure was done. In the evening, my lord, I was picked up by the BSF officials. I was taken to the BSF camp, and my lord, this case has been.
No, recovery was from your house.
No, not my house, my lord. Not my house. There is not a single document on record which shows that the recovery was done from my house.
That is not from your position, not from your personal position. It was not, you were not searched in person, but your premises was searched.
I was searched in person as per them.
Okay. And place of recovery?
They say that it is my house.
House, yes.
They say it is my house.
Which you're very annoyed.
And you are the sole accused.
I am the sole accused. They say the electricity is in my father's name.
Let us hear, Mr. Mujumdar.
They say it is the electricity of the house is in my father's name.
There's no document on record.
No, my father has also not been made an accused. Only averments, my lord, nothing to establish.
Yes, Mr. Mujumdar.
Lordship, it is an admitted position that a huge quantity of contraband was recovered from the house of the petitioner.
Show us one document to the effect that the petitioner is the owner of the house.
My lord, then I have to find out if there is a document with the department.
Trial is going on, Mr.
Caesar, it
Mujumdar.
must be in the Caesar.
No, my lord, then I have to find out the trial court record. The trial is on.
Secondly, your independent witnesses have turned hostile.
My lord,
Thirdly, there is no signature of the
right, my lord.
petitioner.
He can take this in the trial.
No, of course he can. But today we'll have to assess that
My
if
lord,
these are mandatory.
Does any of these indications water down 37?
Yes.
My submission is no, my lord. Because we have come across Supreme Court judgments which says even if the contraband that was seized from the possession of the accused subsequently was found not to contain any narcotics, still bail was refused.
Show us that decision.
Namaskar. So I'm just reading out and handing over the judgment.
Actor. Which paragraph?
Yes, para 16 to 18.
Lordship. No narcotics was traced in the contraband, yet Honorable Appeals Court said no. 37 is not. Yeah, diluted.
Paras?
16 to
16,
20.
20. ওটা তো ভালো দিন না এটা বার করলে হবে তাহলে অবস্থানটা ঠিক আছে 16, 17, 18 বোধহয় 20, 21, 10 আছে আমাদের একটি
Totally different.
But then, Mr. Mujumdar, there are also decisions to the effect that, for example, 52A, if it is not complied with, then the conviction will ultimately not be sustained. Therefore, bail should be granted.
My lord,
Yes,
my lord, all the judgments that I have come across, subject to correction by the bench, my lord. The Honorable Apex Court has most of them dealt in the final appeal against the conviction and said 52, 44, whatever is not compliant, you are acquitted. But Honorable Apex Court has never watered down the bar of 37 for whatever circumstances. Honorable Supreme Court's view is this, that you have to satisfy the twin conditions under 37, come what may. And the two twin conditions, my lord knows very well. There is one corollary that the public prosecutor has to be given sufficient opportunity if he objects, and if he objects, then these two things has to be satisfied. That
Come back with the case laws that are in your favor.
I have today itself.
You have today.
Yes, but I'm carrying.
Make a compilation.
Lordship.
Make a compilation and file them. We have followed the arguments.
Right.
Kindly ask your junior to do the same,
Doctor.
Mr. Mujumdar. We'll reserve order in this matter because one needs to go through all the decisions and pass a detailed judgment. We have understood the arguments and very short 2-page note
Yes.
with the judgments.
Yes.
We'll keep it as to be mentioned on Wednesday. We give you sufficient time.
Lodge.
Hmm?
And I will submit.
Exchange.
We'll exchange.
You exchange?
Yes.
On that day, we will reserve judgment.
Lodge.
Hmm?
Get to it.
Heard
Yes,
learned
Lord.
counsel for the parties. Stop. Hearing is concluded for all practical purposes. Stop. Paragraph to enable the parties to file short written notes of arguments and bunch of judgments that they rely upon, comma. Let this matter be listed again on Wednesday date under the heading to be mentioned.
Grateful. I'm grateful. With your leave, Lord.
Item number 6.
But this case relating to NDPS case. But allegation is that on 7th of January 2024 at about 1 p.m. But acting on a source information, police contacted the house of the petitioner at his allegation and what commercial quantity of malad cough syrup and malad tablets are recovered. But in this case, malad charge sheet was submitted on 31st of May 2024, malad. And charge was framed on 8th of August 2024. Malad, after framing charge, but at least 15 dates has been malad elapsed. No witness 15.
When charge was framed?
8 তারিখে তুমি দেখো আমি অর্ডার অ্যানেক্স করেছি
Next date is fixed of 20th of November for
But
evidence of CSW.
But kindly see
How many witnesses are named in the charge sheet?
15 witnesses.
Who is Prakash Rai, a co-accused?
Well, Prakash Rai was
Nothing
sitting
was
already
recovered from him,
granted,
but from
granted,
this person,
granted bail, my lord.
recovery is there.
Caesar list says so.
Caesar list, yes.
So recovery from both the accused
No,
persons?
my lord.
Only from this
Exclusively
person?
from this person, Anup Chetri.
My lord, kindly see.
You are in custody since January.
General, but about 300 days, my lord.
We have collected the FSL report.
Now the
within
question
time,
is,
charge
if
sheet
there
has
is a
been filed.
recovery from this person, how can you claim parity? No, I am not claiming parity. I am just informing
The
another.
charge sheet was filed with the FSL report?
Yes, ma'am.
But kindly see page
No,
number 12, my lord.
we have seen, sir. The date has been fixed. What was seized?
My lord,
11 bottles itself a commercial quantity, first item number 11 bottles, more than 10 is commercial. 54 strips of SP Fent capsules, 78 numbers of SPS Vencidal capsules, 104 numbers of lot.
See how it proceeds. We are at this stage, we are not inclined to. We give you a choice. Suffer a rejection or
And then not this.
not pressed.
My lord, I am for the petitioner.
Yes. What was seized?
Says 409 kg of ganja.
400?
409.075 grams of ganja.
My lord, charge sheet was submitted on 12th March 2024. Till date, no SP report has
400
been.
grams of ganja?
400 kg.
Kg.
409 kg.
Yes.
My lord, charge sheet was submitted 12th March of 2024. Till date, no SFL report has been filed, my
My
lord.
lord, supplementary charge sheet filed with CFSW.
After supplementary charge sheet.
When was
Why not?
supplementary filed? Within 180 days?
Just a second, my lord, just a second.
When were you arrested?
He was arrested on, my lord, 17th of September 2023.
My lord, I am in custody for 416 days.
Trial has not started.
No.
No, your lordship. Supplementary charge sheet without.
How many witnesses?
14 clinics.
In these projects, my lord, one judgment has been by my lord, I'm one copy, my lord. Kindly appreciate, my lord, paragraph 32, my lord.
a very recent judgment of the Apex Court, my lord. Apex Court in the High Court of Delhi. Pass over.
Number 8.
My lord, I'm for the petition. Not case diary is not available.
When?
My lord, tomorrow, my lord. If you have late, my lord.
9.
My lord, in item number 9, I am appearing on behalf of the Custom Department, on behalf of the prosecution. Kindly
Yes.
fix it Monday, my lord. CD is not with me. Kindly
Monday.
fix it Monday. Grateful, my lord. Grateful.
My lord, I'm appearing for this case. My lord, some subsequent changes have occurred, my lord. I'm praying for Monday if the matter is taken. Because after filing of this petition, my lord, charges has been filed on 31st of October. And since it was closed, my lord.
Monday. Chalo.
Submitted
11.
11, my lord, case diary is not available, my lord.
Not today.
My lord.
12.
But I'm bothered. But this NDPS case from section 21C of the NDPS Act, my lord. Allegation is that, my lord, on 21st of September 2024 at about 7 AM, my lord, the BSF personnel, my lord, conducted raid in the house of the, allegedly in the house of the petitioner, and my lord, huge quantity of, my lord, tablets and fentanyl have been recovered. My lord, my first point is that, my lord, in this case, but there is absolute violation of section 50. And on the regarding section 50, I am, my lord, relying two judgments, my lord, 5. On judgment 5, judges bench judgment, kindly see. I have paragraph 12, 22, my lord, kindly see. I have the mark the page. Paragraph 22, my lord, is a mandatory provision, my lord, section 50. And in this case, my lord, seizure was made without any, my lord, gazetted officer or any magistrate, my lord. Paragraph 22 of my lord, of the judgment. And another point is that, my lord, paragraph 22. Left.
Again, the problem is that this was against a conviction order, the appeal.
Yes, my lord, but this is a mandatory provision, my lord.
Even then, does it, as Mr. Mojumdar said, does it water down the restrictions in 37? You can well argue this point at the trial, no problem.
Yes. Then, my lord,
Does it water down 37 restrictions? Can we
Another-
hold that there is reasonable ground to believe that you have not committed the offence?
Well, another point is that, my lord, the house, my lord, where the seizure was made, there is no document to show that that house belongs to me. I am not the owner of that house, my lord. And
Page 24 is the seizure list.
Yes.
There are so many seizures.
And my lord, another point is that, my lord,
No, the Caesar list has your name, it names you.
Yes, that is, I am actually, I am deciding, I am actually having tea in a tea shop, and the recovery was made from a house that was not mine. Kindly fix the matter on Wednesday,
What for? We are not deciding that matter on Wednesday. We are only reserving judgment on Wednesday.
But that is also section 50 after conviction, but there is a delay of there is delay of seizure and inventory, and till that no.
How long you are in custody?
He was arrested on
Two months.
21st of
September.
September this year.
No. Issue. The petitioner says that he is not involved in the alleged crime. Stop. The seizure of the alleged crime. Stop. He further says that the provisions of Section 50 of the NDPS Act 1985 have been breached. Stop. He relies on a judgment of the Honorable Supreme Court in the case of ETA, the other way, or its criminal appeal number to worship the other way. Stop. He prays for bail. Stop. Paragraph, Learned State Council opposes the prayer. Stop. He says that the seizure list will show that huge quantity of narcotics was recovered from the house of the petitioner. Stop. Investigation is going on.
Yes.
Investigation is in progress.
Going on.
Stop. Paragraph. In view of the in view of the much more than commercial quantity of narcotics involved, keeping in mind the restrictions in Section 37 of the NDPS Act, we are not inclined to enlarge the petitioner on bail, at this stage. Stop. Further, investigation is going on. Stop. Paragraph, the judgment relied upon by the petitioner was passed in an appeal preferred from conviction. Stop. The conviction was set aside on the ground of non-compliance with the provisions of Section 50 of the NDPS Act, which was held to be mandatory. Stop. The judgment, however, does not discuss as to whether at all, and if so, to what extent, the restrictions in Section 37 of the NDPS Act are watered down if there is non-compliance with the provisions of Section 50 of the NDPS Act. Paragraph, in view of the aforesaid, this application fails and is dismissed.
Very good.
একটা লিখে দিও তো, the petitioner says যখন গোড়াতে যেখানে petitioner কথা বলছো, that he is in custody for about 3 months.
54 days.
54 days. 47 days. We have said at this stage, so you can come back.
Item 7, which was Passover, can it be tomorrow, Monday?
Who is the petitioner?
Item 7.
I am first.
Monday?
Monday.
Item number 17.
এর আগের কোনটা ছিল? এর আগেরটা কোনটা? ফারুক। Yes.
I appear on behalf of the petitioner, my lord. My lord, before we come up to hearing, my lord, the three fundamental principles of natural justice is justice, equity, and good conscience, whereby the equity will play a fundamental role in this particular case, my lord. Prior to
When were you enrolled?
Yes,
When
sir.
were you enrolled as advocate?
2020, my lord.
2020. Yes.
My lord, I am handing over the written notes of argument prior to this case because
Written note on a
short notes, my lord.
NDPS. What was seized from you, sir?
My lord, cough syrup of 2,275 bottles. But my lord, there is a gross violation of 52A itself, my lord. Now, my lord, if we come to the come to the, my lord, the FIR, the written complaint.
There was no certification.
No, the certification was very improper, my lord. The certification was more or less, my lord, the certification was.
তাহলেই তো এই যে যেদিন কি দেওয়া আছে the discrepancy has value could be analyzed and considered at the appropriate stage of the action. তাহলে এখন
I don't know what is the change.
তাহলে এখন
You have suffered a rejection before.
Yes, my lord, this is the second bill application.
Huh?
Yes, my lord.
That is, look, sir, that is the first thing you should mention.
Well,
Otherwise, the court will have the feeling that you were suppressing it,
I apologize for that.
right? So on 10th of April, you
Yes.
suffered a rejection on merits. This point was considered by that bench of which my brother was a member,
My lord.
right?
My lord.
Why should we entertain your application now, excepting if there is a change of circumstance?
My lord, the change of circumstances is the deposition of the complainant, my lord, whereby he denied many things. Firstly, usage of investigation kit, which he have prima facie mentioned in the written complaint, but during his deposition, he stated no. Secondly,
We are not going to assess the evidence, analyze the evidence, sir.
no, but my lord,
That is the job of the learned trial court.
yes, my lord, but my lord, if my lord may come to this point, my lord, the 52A was done where it is prescribed of 72 hours.
Argue it at the trial.
But my lord, this entire articles was lying with the police personnel, my lord, and it was never videographed even. The videography was never even the seizure. The 52A of the videography was also improper.
How many witnesses are there in the charge, named in the charge sheet?
My lord, witnesses are, my lord, 15 witnesses.
How many examined till date?
My lord,
Only PW1.
PW1, my lord.
How long you are in custody?
More than 406 days, my lord.
More than 406 days.
Let there be a direction for expeditious.
But my lord, consider
In a
one
time
point,
frame.
my lord, consider one point that if the seized articles were lying vulnerable.
No,
with
you
the
see,
police
we cannot
personnel.
go into all these things because trial has started.
Lordship.
And these things were considered only if there is a delay of trial. That is the only ground.
Correct.
No other ground can be taken at this stage.
Religious privilege. Religious privilege. Expeditious hearing, generally.
My lord, kindly give a time frame, my lord.
That we cannot, unfortunately. We were doing that, but the Supreme Court has said that you cannot do that. The petitioner renews his prayer for bail, which was rejected on merits on April 10, 2024. Stop. We do not find any change of circumstance since then. Stop. Hence, we are not inclined to entertain this application for bail. Stop. Paragraph, we are told that the trial has started. Trial has started and evidence is being recorded. Stop. Considering that the petitioner is in custody for 406 days, comma, we request the learned trial court to expedite the trial as much as it can and conclude the same on an early date.
My lord.
একটা খালি add করে দাও তো। How many bottles you said, sir? 2276.
1275, my lord. It's quite a.
2275. ওইখানে first paragraph allegedly 2275 bottles of penicillin.
No. Codeine phosphate.
Or codeine phosphate was recovered from this petition. That could be. Cough syrup containing codeine phosphate. Cough syrup containing. Cough syrup containing codeine phosphate.
22 and 23. Lordship, 402 days in custody. Lordship, charge
No,
has been
Shiv,
filed, but no
I
charge
know
has
one
been
the
set.
application, Lordship, we don't.
But this was the password matter that
Password.
22 and 23. I am for 23. The other year is on for 22. The same case diary.
Same case.
Item number 23 of an anticipatory bail application.
22, I am in custody for about 402 days. Your lordships, charge sheet has been filed, but no charge is filed. And charge sheet is filed, it is the renewal of my application, which was turned down earlier on 12th of August 2020.
When was charge sheet filed?
Charge sheet filed on 22nd March 2020. No
26
charge is filed. How many witnesses, charge sheet witnesses?
13.
Charge sheet filed without official.
Lordship, I can only give answer regarding 23.
This is.
Who is for 2022?
Okay, CD is here, CD.
CD is here.
Same CD.
No, but the learned advocate is not there.
Lordship, in 22, he is the person from whom the contraband articles were seized. But in 23 is anticipatory bill. So from leading to his statement.
Now the, okay, let the other side come.
I'm
Lordship, this is the
appearing.
case.
No, but 22, who is appearing, Mr. Ganguly?
So Acharya is there. Follow me?
Will you hold this brief and do it or what?
I don't have the brief, I have the case diary. Lordship, he has the brief. He has the brief.
Yes, FSL report is still not available.
FSL report, Lordship, the charge sheet's last line says, keeping provision of submitting supplementary charge sheet after obtaining the.
So as of date, FSL is,
no.
no, then we have to pass that order. If you have a copy of that order, we told you.
Yes,
Our
yes.
order in the other
I have
matter.
already-
Wait.
Yes.
Same order issue এখানে খালি custody
Custody is 402 days.
402 days হবে এটা খালি।
And trial not commenced.
Twenty-two.
And 23 is not
No,
anticipatory.
23 will
23 I'm appearing.
আলাদা করে দেবো, 23 আলাদা করে দেবো, হ্যাঁ।
My lord, he was not named in the FIR, my lord. He was named in the FIR, lordship, and the only allegation against him is that.
Named or not named,
Lordship, he
decide.
was named in the FIR.
Named in the
Lordship was
FIR.
named in the FIR on the strength of the statement of the co-accused. Lordship is very well aware of the fact that there is a bar under section 67 that.
No recovery from him.
No recovery from him. No, there is no recovery from me. And lordship, they were the second point which was taken by the prosecution is that there were telephonic calls between the accused and the present petitioner. Lordship, I will play, if my lords permits, then I'll place a judgment of the Honorable Apex Court and the Delhi High Court, my lord, where it has been categorically stated that CDR is a question of trial that has to be argued at the time of trial, your lordships.
Yes, that's good. Will be, you know.
It also switched 67. Lordship, this is with regard to section 67. And lordship,
তাহলে দুটো জিনিস একটা হলো
Correct, FSL report.
and lordship, Tufan Singh's judgment.
Mr. Huh?
Lordship, this is Tufan Singh's judgment, lordship, which states that statements given by the under section 67, lordship, they are not admissible in evidence. Lordship, shall I?
You wasted so much paper.
But
We'll grant him bail. Stringent conditions and anticipatory bail. Yes. The petitioner says that এটা কি? The petitioner says that he has been falsely implicated. Stop. His name has been included in the first information report on the basis of statement made by co-accused persons. Stop. The petitioner has no truck, TRUCK, with the transaction regarding contraband items. Stop. He says that he is prepared to cooperate with further investigation, if any. Stop. He prays for pre-arrest bail. paragraph opposing the prayer, comma, learned state advocate says that huge quantity of
One second. Worship, huge quantity of spasmoproxybin plus capsule.
Also, those are painkillers, which is presently banned.
contraband items.
2018 industry.
Contraband items is involved stuff. The petitioner has evaded investigation stop paragraph, considering the fact that the petitioner has been implicated on the basis of statement of a co-accused person and that the prime accused has from whom recovery was made, comma, has been granted statutory bail today itself because the FSL report was not filed with the charge sheet, comma. We are of the view that immediate custodial interrogation of the petitioner may not be necessary so long as he cooperates with the investigating officer, cooperates with further investigation, cooperates in further investigation, comma, if any. Huh? What is this
Lordship,
crime?
Lordship, there's a restoration application. Lordship, there was a delay of 82 days in filing the restoration application.
Those were allowed already.
No, Lordship. Lordship, I deeply apologize. Lordship, I should have.
Has to be allowed first.
Lordship, I humbly apologize, my lord. My lord, there's a delay of only 82 days, my lord.
Cran 1 is what?
Lordship, Cran 1 is the restoration application, and Lordship, Cran 2 is the application for continuation of delay.
Cran 1 is the section 5.
Cran 1 restoration. What's up, copy?
Cran 1 section 5.
Copy.
Cran 1 is delay. What are you saying? What are you saying, sir?
I'm apologize, my lord. My lord, Cran 1 is the
The
application.
Cran 1 now. This is an application for continuation of delay of 82 days in filing an application for restoration of PRM bracket A 526 of 2024, which was dismissed for default. But with the Cran 2 দাও এক কপি করে রাখি which was dismissed for. Where's the dismissal order?
পেছন দিকে রেখেছে
আছে dismissed for default on August 13, 2024. Causes shown being sufficient, the delay is condoned, a Cran 1 disposed of. Next, Cran 2 now. This is an application for restoration. দুটোই তো Cran 1 দিচ্ছ।
না এটা Cran 2
তুমি আমাকে দুখানা Cran 1 দিয়েছো, তাই আমি বলেছি।
Cran 2টাই
হ্যাঁ, Cran 2টা নাও। This is an application for restoration of CRM A 526 of 2024, which was dismissed for default. বলেছি তো on such and such. Having heard learned counsel for the parties, we are satisfied with the explanation furnished for absence of learned advocate for the petitioner on the day the matter was dismissed for default. Paragraph accordingly, the order dated is recalled. Stop. CRM A 526 restored to its original file and number. Cran 2 disposed of. Next, এবারে তুমি application নিয়ে যে অর্ডারটা দিলাম ওটা করবে।
My lord, I apologize for the discrepancy. I'm very sorry.
I should fine you 4 आना।
Item 60.
60